Chair.
Jacinda Ardern.
Thank you, Mr. Chair. I want to come, I believe, to a part of the bill that hasn't been debated thus far, and that relates to the amendment to the Criminal Investigations Bodily Samples Act. It's subpart 3. It's in part 2 of the bill. I think there's probably the fact that we're canvassing such a wide range of issues from trafficking, human trafficking, to facilitation payments, and to things like the sharing of DNA information between countries does demonstrate that this is indeed an omnibus bill. But in this part of the Act, the amendment to Criminal Investigations Bodily Samples Act 1995, without seeing the context, it's probably very difficult to see why such a requirement is necessary. And that's why I wanted to canvass in a little more detail the problem that we have, just to ensure, I guess, that we have opted for the right options in updating our legislation, because 5 options have been canvassed by officials. So the current situation that we have, Mr. Speaker, is that periodically the police will receive requests from overseas agencies for DNA profile, and that's most likely currently to come from the Australian authorities, interesting given the current situation we're in, via Interpol. But there is an inability at present for New Zealand to legally provide information about DNA profile to our counterparts in Australia. And that's because the current legislation that governs the DNA data bank is the Criminal Investigations Bodily Samples Act of 1995. And that does not permit DNA profile information to be provided for an overseas agency for the purpose of investigation. Now, what's interesting is that we have had for some time a mutual assistance in criminal matters agreement. That was put in place in 1992. Our bodily samples bill came in 3 years later, and yet for some reason that bill did not factor in the fact that we had that mutual assistance agreement. Now, what that means in practice, and an example that is used in the regulatory impact statement, is that the Queensland Police investigating a homicide may take a DNA sample from the crime scene when they ask the New Zealand Police whether or not there is a matching sample in New Zealand's data bank. But even if the New Zealand Police go ahead and carry out that analysis, if they come up with a positive match, they are unable to disclose who the matching sample belongs to. Now, obviously, that will seem curious to people in this House, but what still seems curious to me is, was there any reason why, given that there was a 3-year difference between when this mutual arrangement was forged and when New Zealand put in place its bodily samples bill to regulate the way we deal with DNA samples, was there any reason why that wasn't explicitly dealt with? Obviously some time ago now, so it might be hard to demonstrate that, but I do wonder whether Parliament gave it explicit consideration and decided against it. I do think in the context that we're in now, where we are in greater information sharing arrangements, particularly with Australia, which is where this provision will take the greatest effect, where we are now, for instance, sharing information between countries about detainees who are parole, who, for instance, might have domestically parole provisions that would apply to them but are being sent back to their home country, that we have that information so that we're able to apply it. I would make the point, though, that that is very different than what we're seeing at the moment, in which members of the House on all sides are advocating very strongly against deportation of people who have, for all intents and purposes, taken on Australian citizenship. But coming back to the bill, Mr. Speaker and Mr. Chair, in subpart 3, there were a range of options to deal with this dilemma. And it seems that of the 5 options that were canvassed, a decision was made not to have a broader information sharing provision within the Policing Act, but to come specifically into an amendment on the Criminal Investigations Bodily Samples Act. I think that's probably the right decision on the part of the Ministry of Justice. They did want to make sure that they narrowed down the provision of this information sharing agreement, and to do that would be to put in the enabling legislation, for the bill that regulates samples itself, rather than something more broad like the Policing Act. But what is interesting is the role that the Ministry of Justice has recommended that the Attorney-General should play in decision-making. And I come to, Mr Chair, the specific, unless the Minister would like to make a, no. Mr Chair, if I may, thank you very much. I come now to the way that it has been set out in the bill itself. And it states under subpart 3, this subpart amends Criminal Investigations Bodily Samples Act, Section 27 amended, access to and disclosure of information on DNA profile data bank, for the purpose of responding to a request under the Mutual Assistance in Criminal Matters Act, so still falling back onto making sure that those requests do come via that agreement. Access to information requested is authorised by the Attorney-General. Important point here. The bill is very explicit that it must be via the Attorney-General that these requests are made. So it's not the police who have the discretion to determine whether or not DNA profiling of a New Zealand citizen is able to be shared ad hocly with any counterpart in Australia who requests it. And it states the request relates to an offence that corresponds to an offence in New Zealand that is punishable by a term of imprisonment of more than 1 year. Now, I guess one of the questions I wanted to raise in light of some of the issues that we're seeing currently is it specific, is this requirement for the Attorney-General to provide that information specific to New Zealand citizens or simply New Zealand-born individuals who may now hold citizenship somewhere else? So, to give an example, if Australia made contact via the Mutual Assistance Agreement via the Attorney-General and sought DNA profiling of someone who was born in New Zealand but now holds citizenship in Australia, how would that be treated, for instance? And because keeping in mind some of the situations we're seeing in Australia at the moment, where obviously the Australian authorities are trying to build cases against who they determine to be New Zealand citizens, who, but for all intents and purposes, have been raised in Australia as Australians. The other point I wish to make is in the second part, the request must relate to an offence that corresponds to an offence in New Zealand that is punishable by a term of imprisonment of more than 1 year. Obviously creating a threshold there that says we do not consider this to be a provision that should be used for things that have an offence that don't have a custodial sentence attached to them. We don't consider that important enough, and we want to make sure that the threshold is reasonable. I think that's really important, but again highlights the absurdity of the situations that we're seeing at the moment, where people who have not been imprisoned for even a year are being deported, and yet under this legislation, a country can't even ask for their DNA information if the threshold is that low. You could be deported for it, sent back to a country you haven't known for 20 years, but you can't even have your DNA information shared between countries because the threshold hasn't been met. That to me highlights the contradiction about what we're seeing in the way Australia is enacting its policy right now, that we won't give you information about them, but Australia will still deport them for a lesser offence than what the threshold we've set in this law. I think that demonstrates something quite critical. I'm glad the threshold has been set there. We shouldn't be just sharing information about New Zealand citizens willy-nilly for what would be otherwise considered by the public to be minor offences in this country, and indeed probably in other countries as well. I think from reading the regulatory impact statement, I'm heartened by the level of analysis that's been gone through to come to the conclusion that of the 5 options, that the bar has been set relatively high, that the Attorney-General will be acting on the advice of Crown Law, will be assessing the seriousness of this offence in the context of the reciprocal arrangement, and has the ability to refuse the request, has the ability to hold that sovereign decision to say, actually, from our threshold that we've established in the legislation, it is not either offence that we consider to be serious enough or it simply does not meet our standards. And I think that's incredibly important. Important also to keep that decision making, I think, away from the police and put it in the hands of the Attorney General. They need to maintain their relationships with their counterparts, with Interpol, via Interpol, and this is one way that they're not caught between a rock and a hard place, between Australian police who will be asking for the information and them being the decision makers in that regard. So, Mr. Speaker, I think it's a provision that demonstrates how much thought has gone into ensuring that we balance the need to cooperate at an international level whilst also preserving the rights of New Zealanders and the information that is held on them. And that's perfect timing, I think you'll find.
Mr. Chair.